Welcome, everyone, to our informational webinar on tenant protections in Tacoma. I'm Rosemary Powers, President of the League of Women Voters of Tacoma-Pierce County and a member of the Tacoma-Pierce County Coalition to End Homelessness. Very glad that you've been able to join us for this event. A few words about how we decided to offer this event, which is co-sponsored by the League, the Homeless Coalition, and Tacomaprobono Community Lawyers. Many of us were concerned about voter confusion when we saw headlines in this summer saying such things as Tacoma voters to decide on competing measures strengthening renters' rights, and, quote, the Tacoma City Council voted to let voters decide whether to keep newly passed amendments or replace them with Initiative 2023-01, end quote. We discussed the importance of getting clear ourselves about what the new city code changes mean and how this differs from the competing Tacoma for All initiative. While the Pierce County Superior Court helpfully determined that only Initiative 01 would be on the November 7 ballot, offering an alternative to the City of Tacoma's new rental code, we still wanted to inform voters about both recently enacted and proposed changes. We asked for assistance from Tacoma Pro Bono and are pleased to welcome Staff Attorney Wyatt Fisher to address two general questions. What does Tacoma's new housing code adopted July 11th, 2023 mean for renters and landlords? And second, what parts of the existing code would change if Tacoma for All's Tenant Bill of Rights initiative 2023-01 is approved by voters? Wyatt is a graduate of the Seattle University School of Law and grew up in the Tacoma-Lakewood area. His daily work as a member of Tacoma Pro Bono Housing Justice Project requires finding productive ways to negotiate the tenant-landlord relationship. We look forward to hearing from him about the regulations in these two rental codes as Tacoma voters prepare to cast their ballots. The plan is for Wyatt to present for about a half an hour and then respond to questions that you put in the Q&A space that you'll find at the bottom of the screen. We'll close the session promptly at 7 p.m. and a recording of the presentation will be available later. I'll give you information about that at the end as well. So Wyatt, welcome to the program, and I'll give it to you.
Hello, thank you, Rosemary, very much, and the League of Women Voters for welcoming Tacoma Pro Bono to discuss this important issue with you. As Ms. Powers discussed, we will be primarily identifying how the July 2023 updates of the Tacoma Rental Housing Code have changed the protections available for renters and the requirements available to landlords, as well as we will be discussing the potential changes to the Rental Housing Code that will be appearing on the November ballot measure. I will point out that before we get going, I am not affiliated with the Tacoma for All proposal, and so I will just be providing my analysis about the measure, but I have been in good communication with the City of Tacoma about how they are intending to implement the July 2023 updates to the Rental Housing Code, and how they're intending to, if the November ballot measure is passed, how they are intending to implement that to incorporate with the July 2023 updates. Additionally, as Rosemary had indicated, a court did rule that the measure that had been sent by the City of Tacoma to the ballot in November was removed from the ballot, so that the amendments that were proposed and passed in July are no longer going to be on the ballot. So at this point, the amendments that were proposed and passed in July are part of the law right now, and then only the proposed measure from Tacoma for All will be on the ballot in November. So Rosemary, if you want to move forward to the next slide. And we will just apologize that unfortunately we tried to make it so that I could be the one that's in charge of moving forward with the slides, but we just had some technical difficulties. So Rosemary and I will be coordinating on that, and I really appreciate that. So first, I'm going to be addressing what does the Tacoma Housing Code adopted back in July 11th, 2023 mean for renters and landlords. Then we'll discuss how the proposed Tacoma for All Tenants Bill of Rights will potentially affect these changes, and then we'll leave room for questions and answers at the end. So first, let's talk about the updates to Tacoma's Rental Housing Code. So these are updates that were approved on July 11th, 2023, and came into effect as of July 2023. July 24th, 2023. So as we get going, as we talk about this, I want to point out that what we're about to talk about is currently the law. Now, if the second piece of what we talk about is approved in November, then that will be incorporated into the law. And then any additional amendments to the law related to the rental housing code must be approved by Tacoma voters for 2 years. The city of Tacoma cannot amend what the city of Tacoma's voters have approved for 2 years after it's passed. So if it is passed in the fall, everything that's addressed, both what has already been addressed and what the voters address, cannot be amended for 2 years other than by the city of Tacoma voters. If the city of Tacoma voters, were to reject the proposed amendments this fall, then the city of Tacoma City Council can additionally amend the rental housing code. So I think that's an important thing to note as we move forward with this, because it, on the one hand, protects voters from additional amendments by the city of Tacoma to weaken potentially the protections that are provided. But on the other hand, it also limits the city of Tacoma City Council from amending anything that has been addressed to better improve the rights of renters. So that's something to keep in mind as we move forward, as we talk about these amendments, both that have already been incorporated and those that are proposed to be incorporated as we move forward. So one of the big important things that the city of Tacoma implemented back in July is that no landlord can issue a notice to increase rent or a notice to vacate or evict a tenant unless the landlord has complied with certain city business license and health and safety requirements. So this is already the law. If a landlord has not registered with the city that they are a business, and they have not registered with the city that they certify that the residential unit complies with health and safety requirements as imposed by the city, then the landlord cannot impose a rent increase, cannot issue a notice to vacate the unit, and cannot evict you. And these are defenses available to tenants if they were to find themselves in an unlawful detainer proceeding. To be frank, the business license requirement is relatively easy to comply with for a landlord, but a landlord does need to comply with that before they can actually go through the process that a landlord must go through in order to legally evict a tenant. So this is a new protection available for tenants. Additionally, when you're first applying for a tenancy, often I will say I'm not a landlord, I'm a tenant. And I have experienced where you need to be able to show that you make a certain amount of income multiplied by the rent in order to be able to receive a tenancy. So Tacoma recognizes that the reality of that is that most of us do not make enough money to make 3 times or 2.5 times the rent in order to receive a tenancy. So the city of Tacoma has implemented a maximum income to rent ratio. Right now, it's specific, and so you want to talk to your landlord about what is the actual specific maximum rent ratio that you need to be able to prove in order to rent a unit. But when rent is below 3 times the HUD fair market rent value, which you can look up online, then the maximum rent that you must be able to show is 3 times the amount of rent. If the rent is if the rent is above or at the fair market rent, then you must be able to show 2.5 times the rent of income. So that might be confusing, to be frank with you. But the moral of the story is that if you feel that you do have an income that is sufficient to show that your income will allow you to pay your rent, definitely double check to see whether or not the Tacoma Municipal Code provides you protections so that you can show that 2.5 or 3 times, depending on what the specific rent that your landlord is requesting, matches up with the amount of rent that you need to be able to show that the amount of income, excuse me, that you need to be able to show that you can afford to provide monthly rent payments. Additionally, a landlord cannot require that you show a social security number. Frankly, the idea behind this is that there are undocumented immigrants who do not have social security numbers available, and the city of Tacoma does not wish for undocumented immigrants to be homeless. Plenty of undocumented immigrants have jobs, have income, can prove themselves their own abilities to pay their rent. And the city of Tacoma has implemented this requirement such that a landlord cannot ban renting to a tenant solely on the basis of a social security number. So if a landlord is requiring a social security number, they must offer another way for a tenant to prove that they have the appropriate income to rent ratio. Additionally, a landlord cannot have a blanket ban on a tenant renting to tenants with a previous felony conviction. A landlord can specifically point to reasons that they believe that a previous felony conviction ties to why they will not be able to rent to you, but there are specific requirements. And so I do recommend, if you do have a felony conviction, that you really look into the Tacoma Municipal Code that is listed here on the screen here, Tacoma Municipal Code 1.95.03B3. There are specific requirements about what a landlord can and cannot screen for when they're renting to a tenant. And so this is another opportunity for tenants who, recognizing that, frankly, the enforcement of our criminal code is not necessarily always is not, let me rephrase that. Our criminal code is disproportionately enforced against people of color and poor people. And because of that, we recognize that having a criminal history does not necessarily indicate the same level of risk of being able to pay your rent or to live in a productive manner in your tenancy. And so this whole section of the Tacoma Municipal Code is about asking landlords to make an individualized assessment of individual tenants when they have a criminal history. And there are specific carve-outs where if they have a specific conviction in their history that a landlord can deny it, but it is much more specific than just having it be so that if a tenant has a criminal history that they cannot be rented to. Because frankly, that creates the conditions for additional homelessness. And I'm gonna take a drink. 1 second. Thank you. Excuse me. Additionally, a landlord must provide notice of screening procedures to their prospective tenants. So a landlord needs to tell a tenant what types of information will be accessed when conducting the screening and what criteria might result in denial of the tenancy. And so this is just an additional important tool for tenants to know whether or not they're wasting their time, essentially, in applying for a tenancy, because tenants do pay $100, $60, whatever it is, for a rental screening report. And if a landlord is not giving them the opportunity to understand that they are not going to be able to rent regardless, that is a violation of the law in Tacoma at this point. And so this is an additional protection available to tenants to A, save themselves money, B, preserve their current tenancies, and C, preserve their right to secure additional tenancies in the future. And so, Rosemary, if you want to move forward, thank you. And I apologize that these are it's kind of small here, so if you can't read that, please do feel free to indicate in the chat and we will explain further. But basically, the city of Tacoma also in July implemented additional regulations on rental agreements. So rental agreements are leases, basically. So this applies to any rental agreement or renewal of a rental agreement that is entered into on or after July 24th, 2023. So I understand that there are leases that were entered into far earlier than that if you renew it. And I will point out that leases can only be 1 year at a time in Washington. Any lease that's greater than 1 year is not valid in Washington. So if you're a landlord or a tenant who feels that maybe this doesn't apply to you, it will eventually apply to you because of the way that the law operates in Washington. So any lease entered into or renewed after July 24th, 2023, they're prohibited from imposing any penalty if the tenant terminates the tenancy pursuant to the law. And there's a lot of protections available to tenants available. And if you have questions about that, I would really encourage you to reach out to Tacoma Pro Bono, and we will advise you about that. Additionally, leases are prohibited from requiring a tenant to pay rent electronically, to provide more than a 20-day notice to terminate the tenancy. And so there are situations where you're on a 1-year lease and you certainly have to give them notice prior to 20 days before the end of that 1-year lease that you're going to terminate. But if you're on a month-to-month tenancy, you just have to give 20 days and you're good, and you can terminate that lease. Additionally, a very interesting new regulation that the city of Tacoma City Council discussed quite extensively is that at this point, at least, the regulation is that dog breeds cannot be banned by a landlord unless their insurance policy requires such a ban. And so we can just be frank that pit bulls and certain other larger dogs, there are often policies that landlords will not accept those types of dogs. And so unless their insurance policy prohibits them from accepting those dogs, they are not allowed to prohibit you from having those dogs as pets. Those are prohibitions. Additionally, and again, this all applies to leases or renewals that are after July 24th, 2023, because that's at least 10 days after it was initially passed by the city council. Leases must also describe the number of occupants allowed to occupy the unit as outlined within the Tacoma Municipal Code. They must describe uninhabitable spaces such as attics, basements, and garages that have not been properly permitted for occupancy. This intent from the city is so that we're not putting tenants in a situation where they had rented a unit that is not actually inhabitable, and then they're put in a situation where they don't have the protections available to them under the rental housing code and the residential landlord tenant code. So, or the residential landlord RLT tenant act, residential landlord tenant act, excuse me. The idea behind this is just that landlords need to specify what is an appropriate habitable unit for tenants and not appropriate habitable units, because it is going to allow for tenants and landlords to be more explicit about what they've agreed to rent out, essentially. And there's also additional regulations that I will get to in a little bit about shared spaces where there's a subtenant, basically, where there might be a master lease holder and then they're leasing it out to others, but we'll get to that in a second. And then finally, the landlord needs to indicate where the rent should be paid, whether that's an online rental portal or if there needs to be a name and physical address that gets sent to, as well as repairs that have been requested. And then finally, if there are any late fees that should be assessed, there needs to be a whole process that goes through. This is a new process that the city of Tacoma implemented, but essentially that quarterly, a landlord needs to provide their tenant notice of what late fees are being assessed and why, so that tenants have an understanding of what they're being assessed against, and gives the tenants an opportunity to put themselves back into proper tenancy and get themselves back in good standing, and B, dispute if there are any disputes about where these fees are coming from. And so it's something that ultimately under the law, there is a process to dispute these, but the city of Tacoma made it more explicit that landlords need to be notifying their tenants so that the tenants have an opportunity to discuss this with their landlords. And ultimately, the intent there is just so that there's open communication and that there's an opportunity for landlords and tenants to resolve the conflicts. And then finally, this is already the law, but a landlord must apply any rent that they collect from their tenant to rent first. And then after all of the rent has been paid, then the landlord can start applying it to any properly accrued late fees or other fees that are not monthly reoccurring fees. And these are the kinds of things that are not necessarily clear to both tenants and landlords. And so I do think it is important that the city of Tacoma has laid it out explicitly, evenly, even though that was already the law under the RLTA. It makes it much more explicit for landlords and tenants so that nobody is confused about how things are supposed to be applied, what is due and what is not due, how people can be evicted and not be evicted, and what types of notice they need to be provided before they can move forward with that process. Rosemary, if you want to move forward, thank you. And again, there's a lot of information that I'm kind of going through here. So if you do have any questions, feel free to insert those questions into the Q&A and we'll try to get through those at the end. The Tacoma Municipal Code also implemented some additional regulations around deposit and move-in fees. These are new. One of the significant ones is that a landlord may not charge more than 25% of 1 month's rent as a deposit for pets. So that's a pet deposit. There's pet rents is a separate thing, and landlords are allowed to charge pet rents if it's part of the lease. But a pet deposit can only be limited to 25% of 1 month's rent. Additionally, another notice, and I don't know whether I'm talking to tenants or landlords at this point, so that's why I'm trying to be pretty broad about this. But previously, a landlord was required to place security deposit into a trust account. Now it's security deposit and any last month's rent. So if you are collecting last month's rent from a tenant, or if you're a tenant and you are paying last month's rent, that needs to go into a trust account. And ultimately, that last month's rent is only last month's rent. It cannot be applied as a security deposit. And maybe this should have been a bullet point in here, but last month's rent is last month's rent. If it's designated as last month's rent, it's only applicable to last month's rent. And otherwise, it should be refunded to a tenant if they paid all the rent. And it's not, the claim is not that they have some sort of damages owing. That's a separate thing from last month's rent owing. Okay. And then additionally, the city of Tacoma has adjusted the installment payment schedules for move-in costs. You can kind of see how that has been addressed here on this slide. Essentially, they changed it so that prior there had been categories of 1 to 2 months rent, and then I think 3 to 6 months rent. It is changed. Ultimately, it's pretty specific, and it's primarily going to affect landlords and how they approach initial move-in. And so I would really strongly recommend that if you're a landlord and you want to understand the appropriate options to offer to your tenants when they move in, that you really look specifically at the law under this, because it is pretty specific, and I'm not going to go through all of that because we don't have time at the moment. But the main thing is that if a tenant does not pay their move-in costs over time, then that you could evict them on the basis of non-payment. But a tenant does have the right to request move-in costs to be paid over a period of time, depending on how long that initial lease was for. And I'm going to take another drink while Rosemary moves the slide. Rent increases is pretty straightforward. So prior to July 24th, 2023, landlords were required in the city of Tacoma to provide 60 days prior written notice to a landlord whenever, or to a tenant, excuse me, whenever monthly housing costs were to be increased. And so monthly housing costs are those costs that are recurring. So it's not a one-time bed bug payment or whatever. It is monthly recurring housing costs. And so that has been increased as of July 24th to 120 days. Additionally, in order for that notice of rent increase to be enforceable and valid, there are specific requirements that a landlord needs to follow. And so that may be a defense to tenants if your landlord did not follow. I don't know if you can see my pointer here, but for a notice of rent increase to be valid and enforceable, a landlord must specify the percentage of rent increase, the amount of the new rent increase, and the date on which the rent increase becomes effective, serve the notice in accordance with this section of the law, which basically means that you need to either be served personally or it needs to be posted to your door and mailed to you. Additionally, there is a city of Tacoma requirement that they need to provide certain resource summaries, and they also need to comply with those city business license requirements that we previously addressed. And so if you do find yourself with a rent increase and you don't think it's right, consider discussing to Tacoma-Probono or another attorney to see whether or not that rent increase was actually valid, because there are quite a few protections that have been introduced as of July 24th, 2023 by the city of Tacoma that may protect you from that rent increase. Late fees. Additionally, the city of Tacoma did introduce some regulations around late fees. Any late fees for the late payment of rent may not exceed 1.5% of unpaid monthly rent, which generally is going to be lower than the amount that you're usually seeing on a lease. So as of July 24th, 2024, late fees can only be 1.5 of the unpaid monthly rent, or a maximum of $75. $75 is 1.5% of a pretty large number. So that's why I'm saying that usually it's going to be the 1.5. And I've given you an example here of what that would look like. Additionally, late fees cannot be charged for any non-rent fees, and that would include legal costs, court costs, attorney's fees, late fees, anything like that. Additionally, like we mentioned earlier, landlords must provide tenants with at least a quarterly written statement notifying them of the late fees that are due and how the tenant can come into compliance. Because ultimately, the city's goal and our goal here is to preserve people's tenancies, and we want to make it such that tenants know what they need to do to preserve their tenancies. And if that's not the case, then it's very likely that a judge is going to find that the landlord did not comply with the requirements that have been implemented by the city of Tacoma and the state of Washington. But when I say that, I do encourage you to speak to an attorney before you move forward with that kind of understanding. Notice to vacate requirements. So similarly, the city of Tacoma implemented additional requirements so that in order to issue a notice to vacate, a landlord has to comply with the requirements of 59-12-40. So that means they either need to personally serve their tenant or they need to post and mail it to the tenant. They need to require that the tenant vacate the dwelling unit at the end of the month or period of the tenancy. And so again, it needs to be pretty specific about what the tenant needs to do. Otherwise, the tenant might have a good defense. They need to say who needs to leave and which specific unit needs to leave, and the reason. Or so often you're going to see a pair vacate notice, but there may be other specific notices, and those notices need to be completely valid and clear in order for them to be enforceable in a court of law. And then finally, as we've kind of addressed a few times, that a landlord does have to comply with the city business license requirements. That is something that you could look up online. It's a relatively easy thing for them to fix, but if they haven't complied with it, it is a defense. And so it may be a last minute resort for tenants who are trying to prevent themselves from being evicted. I'm going to go kind of quickly through this part because I do want to leave room for questions. But shared housing, basically the city of Tacoma recognized that shared housing is an important factor available to people to have housing. Often what that looks like is there is a tenant, whether it's well, it doesn't always have to be a tenant. It could be a homeowner, or it could be a tenant who is leasing all or part of a unit, and then they sublease out to other people. But there are specific protections available for people who are living in shared housing situations. I will say that the city of Tacoma, as they were promulgating, as they were putting forward these amendments, did not do a great job of writing this portion of the law. And so there may be additional amendments to come, or if the Tacoma for All amendments were to pass in the fall, then that wouldn't come for over 2 years. But there are some kind of weird conclusions to be made from this section of the law as it was amended. And I don't necessarily want to speak on all of that because I don't know how the city attorney is going to address that and how the Tacoma for All initiative might affect that. But I would just recommend that if you are a tenant or a landlord in a shared housing situation where either there are 4 or more tenants in a dwelling unit that share a space and they have shared common spaces, or if you are subletting from someone who is not the owner of the unit, I would recommend you look closely at these laws and the protections available, because it's pretty specific, and I don't necessarily know how the city of Tacoma is going to address some of these concerns at this point, to be honest. Compliance and enforcement. So the city of Tacoma does have some tools to tell a landlord basically to come into compliance with the laws under the Tacoma Municipal Code, Rental Housing Code. I've listed out kind of some of the civil penalties or some of the sections of the law that where a landlord has violated them, the city can impose civil penalties. And so if you do feel that your landlord or a prospective landlord has violated these, I do recommend reaching out to the city of Tacoma if you're in the city of Tacoma limits, and seeing whether the city is willing to either enforce the law and tell the landlord that they need to come into compliance, or provide you with an opportunity to relocate. It just depends on the circumstances that you find yourself in. But there are certain relocation assistances available when a landlord is pretty egregiously, to be clear, pretty egregiously not complying with the code, the city code. But it is an additional resource available for you. And I feel like if we move to one more slide after this, I think there's some links available. Rosemary. Yeah. So if you're in the city of Tacoma, you can call 311 or that number right there, the 253 number, if you're not inside the city limits. And there's also 2 online forums depending on how serious your issue is. So these are some of the resources that are available for you, and some of the protections that were additionally implemented in July by the city of Tacoma. And so that is the law as it currently exists. And I realize it's currently 6:40. And so if someone who organized this wants to cut me off, feel free. But I'm happy to go over the Tacoma for All proposals as well. So Tacoma for All. So go ahead.
Yes, please do that part.
Okay, great. So I will note that I am not affiliated with Tacoma for All. I am a staff attorney at Tacoma Pro Bono, and so my primary role is analyzing the law as it is, analyzing laws that may or may not end up being implemented. And so I'm going to take another drink. So, originally, the city of Tacoma, when they implemented the law that we went over previously, they had implemented it and then also sent it to the ballot in November for city of Tacoma residents to vote on whether or not to pass. Additionally, in that same city council meeting, there was also a proposal from Tacoma for All, excuse me, to amend the rental housing code with different, sometimes overlapping protections for renters. At that time, the city of Tacoma had sent both of those proposals to the November ballot. Since then, a judge has ruled that because the city of Tacoma implemented their proposal, it would be confusing to send it to the ballot alongside the Tacoma for All proposal. And so the judge ruled that what the law was that was proposed and accepted in July is the law, but it does not need to go to the ballot in November. So the only thing that's going to be on the ballot in November is the Tacoma for All proposal. Okay. So again, looking at this screen right now, the overview of the red line changes can be reviewed if you look at the substitute ordinance number 28894, which took effect on July 24th, 2023. And the reason I want to kind of point that out is because in that law, it does say that if there are errors or there are some weird things in there that were not right, that the city clerk does have the right to fix those, basically. And I would say that there are errors in that, and I have pointed those errors out to the city, and I do expect that the city is likely to fix some of those errors. So it's not quite as straightforward as just reading the law as rewritten, because there are certain circumstances where that's not necessarily exactly the case. In particular, there is one instance where because of the way the law was amended, it references a different clause of the law than it had previously. And that's the type of thing that can be fixed by the city clerk without an additional amendment. However, these are kind of the major changes that were implemented on July 24th. So if we move on to the next slide, we see what the Tacoma for All proposal would be. As we go through this, I want to note that some of this does not conflict with what is currently the law, and where it does not conflict with the law, it will not amend the law. It will only amend the law insofar as it conflicts with the law if it is passed. The additional thing that is important to consider that I frankly, and again, like I said, I'm not associated with Tacoma for All. I'm also not an employee of the city of Tacoma. I'm an employee of Tacomaprobono, which is a nonprofit organization. I don't necessarily know how the city intends to implement this if it is passed, because what it says, as you can see on the screen, is a new chapter is to be added to the Tacoma Municipal Code. Now, the rental housing code is a chapter of the Tacoma Municipal Code. And so hypothetically, what it says is that it should be a new chapter. But a lot of what is contained within the proposal is already part of the Tacoma Municipal Code. And so I don't entirely know, frankly, how the city clerk or city attorney or whoever will actually implement it. But this is the proposal from Tacoma for All that I'm going to go over with you. And the key kind of takeaway is if it does conflict, then it should be added. If it doesn't conflict, then it should just be incorporated or ignored, essentially. So we can kind of go through this, and I apologize that I don't have a clear explanation for you. So first, it's important. This is something that I don't think necessarily the public always understands, but intent is important in legislation. And so it's important for any legislature, whether it's a city of Tacoma, whether it's a state legislature, to explain their intent, because when it's unclear what they were trying to do, or there's a conflict in the language, a judge is likely to look to the intent as stated by the legislature. So insofar as that is a piece of importance, that's why I've included this slide about what the findings of the city of Tacoma are if the city were to adopt this measure. But it doesn't actually have any operative effect. So we can move on to the next slide. So adopting the Fairness Code, the Landlord Fairness Code, landlords must apply with tenant protection laws before raising rent or evicting a tenant. I think in a lot of ways that's kind of already part of the law, but I think that there is likely to be additional amendments that the city attorney would have to make to ensure that that actually incorporates into all of, if this were to pass, the additional protections that are provided. Landlords must not charge unfair or excessive fees. That's going to be something that is open to the interpretation of a judge or any number of judges or commissioners without additional definition or rules around that. Landlords must give advance notice of rent increases. That's essentially already part of the law right now. And without additional clarification, I don't know that that would actually amend the law at all. But then it says, and pay relocation assistance when significant rent increases require tenants to relocate. And I know that there's a significant part later on in this proposal that addresses that. So we'll come back to that. Additionally, this is a big change from the current law. Landlords are prohibited from carrying out student or school year evictions and cold weather evictions. And so that would create a significant defense for tenants to not be evicted during certain times of the year based on the weather, or if they have a student who's in their unit, or I believe, and we'll go through this further, student or teacher who lives in the unit to be evicted during the school year. So that would be an additional defense available for tenants. Number 5 is essentially already part of the law, so that's why we're not addressing that. There's also a section that gives additional protections to a tenant from rent increases. So you look here, 2A, section 3, 2A is already essentially part of the law, right? It is determined to be in violation of tenant protection laws related to health and safety. We previously discussed that that would be a defense to a tenant's eviction. Additionally, a landlord shall be prohibited from increasing a tenant's rent if the dwelling unit has defective conditions, making the dwelling unit uninhabitable. If a request for repairs to make the dwelling unit habitable has not been resolved, or if the landlord is otherwise in violation of their duties under the law. So this is a stronger protection than what's currently under the TMC. And so it basically say that a landlord cannot increase the rent if they have not complied with all of their duties under the law. And then number 3 under this is essentially what's already the law right now, which is that they need to be able to show that they are not in violation. A landlord needs to be able to show they're not in violation of health and safety laws. So it provides additional protections. Additionally, it specifies what unfair or excessive fees are. So it limits late fees. And you can kind of look specifically at what this says here, but I've tried to highlight the additional protections or rules, depending on your perspective, are under this. Additionally, one of the big differences between this proposal versus the current law is that landlords will be required to give 2 notices of rent increase. The first notice would be provided between 200 and 180 days of the rent increase. And then the second one would be between 120 and 90 days. Right now, there's currently a requirement of 120 days increase within the city of Tacoma. So it would change that regime entirely. And I'm going to take another drink. Thank you. Additionally, it also provides for relocation assistance for tenants if the rent increases 5% or more. So that's a big difference between the current law and what the proposed law under the Tacoma for All proposal is. And it's pretty specific. It says that relocation assistance is per dwelling unit, not per person, and shall be split evenly among the tenants. And so essentially it's kind of a background way to restrict rent increases. And then the rent assistance amount, the relocation assistance amount, excuse me, should be equal to 2 months of rent. And so I would really encourage you, if that you are intending to increase your rent amount, and this does pass, that you really take a look at what that says. Under the school year and cold weather evictions, basically, it kind of lays out what that looks like, that if it's a child or student, a person having legal custody of a child or student, or an educator, and then cold weather evictions apply between November 1st and April 1st. So it does provide pretty significant protections for tenants if they're being evicted in certain time periods. And then, so basically this provides tenants the right to maintain their tenancy if a landlord does not properly comply with the additional restrictions that are imposed by the proposed amendments here. And so I've just highlighted a couple here. Again, I'm trying to highlight what has changed. And so failure of a landlord to comply with any provisions of this chapter, and again, keeping in mind that what is proposed here is pretty significant amendments, shall provide the tenant with a defense in any legal action brought by the landlord to recover possession of the dwelling unit. So it would be a defense to an unlawful detainer. And then I think it's pretty significant, actually, that this number 4 here under Section 8 is that a tenant or an organization representing tenants may seek injunctive relief on their own behalf or on behalf of other affected tenants. And my sense, and I could be wrong about this, my sense is that that's a pretty significant change insofar as it makes it much more explicit that when a landlord is violating terms of the lease or the RHC or the RLTA, that tenants organizations can also on their behalf seek injunctive relief. And I do think that that would be a significant benefit for tenants and tenants organizations. But I do also recognize, just being real, that it would be a significant challenge for landlords and their organizations. And so that's just something to be aware of as you're looking at kind of this piece of the proposed regulations. And then also they provide some definitions. And so again, like I said, if it doesn't conflict with the current law, then it'll just be ignored or incorporated. If it does conflict, then it'll be additionally added. And I don't necessarily know how that would look, whether it would be a new chapter as this initiative asks for, or if it would be incorporated into 1.95, which is the rental housing code currently. And then some miscellaneous provisions, excuse me. These are some other things that you just want to kind of take a look at, but basically it's pretty straightforward, and it kind of complies with what the RLTA already states. And so at this point, we would open to question and answer. And I do see in the chat right now, there are 2 questions. So I'm going to start with that. And if anyone else who is in charge of this is welcome to organize as well, but I'll just get going on that. So I see one from anonymous attendee at 6:20 that says, does the current law indicate whether rental applications are first in, first considered, or whether they are evaluated on a competitive basis? Okay. And so what I would say is that my understanding, and feel free anyone else to pop in on this question, is that there is not necessarily within the overall state of Washington regulations a requirement that it must be first come, first serve. I do know that in the city of Seattle there is, but I don't know that in the city of Tacoma at the moment there is. But if anyone else wants to pop in on that question, I'd be happy to be corrected. So no, unfortunately, without any additional without additional input. It sounds like unless there are additional protections passed by the city of Tacoma, whether that would be additional amendments in the future or citizens initiatives, no, a landlord does not have to consider rental applications first come, first serve in the city of Tacoma. The next question is, isn't it unlikely that a tenant living in a substandard unit would report their landlord to the city because they could then be in-house? Yes, I do think that's a very important consideration. And when I talk to some of my tenants or my clients, that's a reality that I need to discuss with them, is that yes, you could report the substandard conditions to the city, and potentially you can find yourself in a position where you can enforce the repairs that are necessary, but it also is possible that you may find yourself in a position where the city or the relevant governmental agency finds that it's an uninhabitable position. But at that point, if that's the case, then generally there are supposed to be relocation assistance available to you, both from the municipality and the landlord itself. And so I could pull up what part of the RLTA that specifies that if you want, but that is a very real concern to be aware of. And that's frankly it goes into the calculus about the complicated nature of power dynamics between landlords and tenants. And Rosemary, did you have something else you wanted to say about that?
No,
Okay.
we have time for a couple more.
Okay, perfect. I see oh wow, it's 6:56 already. Would it be possible to evict students and teachers that are in school year round? That's a great question. I believe what the law says right now is that, I'll try to pull it back up, but I believe that it specifies specific parts of the year that it would be, that might be wrong, actually. The more I think about it, that might be wrong. But I would say that that's certainly a legitimate question to bring up to the city of Tacoma. I wish I could pull it up right now, but I'm not finding it at the moment. I apologize. I don't know where it went. I'm so sorry.
Would it be possible to later post some answers to these questions if you can't do it during this
Yeah,
forum?
definitely. And I would also say that I am in contact. I work for Tacoma-Propobono. I am in contact with the city of Tacoma. I think it's their civil rights department actually, but they're a landlord tenant intake kind of group. And so if you do have any additional questions that you want me to kind of bring to that group, I'd be happy to bring it. And I will start with this question about evicting students and teachers that are in school year round. So I think that's a really good point, actually. But for now, I'm going to move on to the next question because we do have limited time, and I apologize for that. What would prevent landlords from avoiding renting to families with school-aged children to limit their exposure? Frankly, I don't know that at the moment there is any on that regard. I think that, yeah, I don't know that there is a protection, to be honest, and that's something for all of us to consider as we kind of think about this proposal. How much notice does a landlord need to give if they decide not renew their lease with a current tenant? That is a pretty specific question. It depends on how long the tenant has lived there, basically. If the tenant has, what I would say is I would suggest you look at 5918-650. It's pretty specific. It depends on whether that tenant has gone on a month-to-month agreement or if it is always continued as a 6 to 12 month agreement. It really strongly depends on that. So I can't provide further counsel on that regard, but I would recommend reaching out to an attorney or potentially just reading through RCW 5918-650.
Looks like we have time for that one more question there.
Okay, perfect. If someone was renting an illegal space, e.g. a basement, would they be required to bring the space up to code in order to evict a tenant? No. My understanding is that they would not be able to legally evict a tenant through the unlawful detainer process. They may or may not be able to use the ejectment process, which is a different separate process than the unlawful detainer process, which is essentially what evictions are. They could potentially do the ejectment process, but I don't know the specific answer. It would kind of come down to what the judge views as the specific scenario that's being presented in front of them. But I do not think that the unlawful detainer process would work in that case.
So thank you, Wyatt. And Jennifer Ammons presented a partial answer to that question about evicting students. So we could look at that. And I
Perfect.
think we need to thank you very much. And because there's more people to do other Zoom events after this one. And I know this was a challenging thing to get this much detail in an hour of time. So if there are other questions, we can send them to you. Is that what you're suggesting? That you would then take them on if you can to places that would deal with them?
Yeah, and so we have kind of a weird funding procedure at my office, but what I would say is generally if you have like a pretty significant legal issue, that you could definitely go to tacomaprobono.org and fill in an intake form, and we can definitely get you scheduled with one of our attorneys, whether it's our help team, which is kind of the pre-eviction team, or the assigned counsel team, which is if you have a summons and complaint for unlawful detainer, then we can work with you on that. But additionally, if there are more organizational questions that would help to kind of disseminate down, I'd be happy to answer those questions, and you can reach out to me. I'm trying to figure out how to send it in the chat, but I don't see the right thing. But you could reach out to me at Wyatt, WYATT, at Tacomaprobono, TACOMAPROBONO.org. And I'd be happy to try to answer those questions. And if I don't have the answer, I'd be happy to refer you over to someone who maybe can help better.
Okay, so thank you very much. And Cynthia, I have a question for you. If this event can be made available for people to view, what is the process we might have available for people?
We will post it on the League website. It'll be a YouTube production, and the link will be on the League website. And I will send it to Rob immediately after getting it posted, which will probably be first thing in the morning.
Thank you very much. And thank you for moving the slides ahead, because it was you, not I. Anyway, that's fine. But Wyatt, it's wonderful to have you here and have your expertise, and look forward to future conversations. And thank you everyone for coming, and let us know if you have questions or other interests.